There have been lots and lots of questions about the video that I posted yesterday regarding the court order from a judge analyzing parental alienation as domestic violence in Arizona. My name is Billy Tarasio. I'm an Arizona family law attorney. And one of the questions I'm getting over and over and over again is, who is the judge? And can we cite to this case? So we can't cite to this case. This case is not case law. Case law happens when the Court of Appeals or the Supreme Court makes a published decision that we can cite that states what the law says. So we don't have that here. What we have is a court order that kind of expands what we've seen in terms of the definition of domestic violence legally in Arizona. The reason is that domestic violence in Arizona's statute 25403.03 refers to the crimes of domestic violence from the criminal code under Title 13. Those crimes don't include parental alienation as a domestic violence crime that you can be charged with. So that was another question that we got is, can dad now be charged with the crime of parental alienation? No, it's not a crime. What this judge did, and if you haven't watched the other video that I'll tag, go back and watch that because it has a lot more information in it about the language and the analysis and the facts that led to this outcome. But the finding here is that the father had engaged in a pattern of behavior that exerts control over a party, invokes fear, and causes harm. Probably through, my interpretation, probably through the use of that language, that will be enough to constitute domestic violence. But the other thing is that this judge has analyzed everything, every best interest factor, all of the behavior that happened between these parties. And so I would be shocked if a court set aside, if the Court of Appeals said that there was an abuse of discretion. That's what they would have to say. The Court of Appeals would have to say that this judge committed an abuse of discretion in her analysis in changing legal decision-making from dad having sole legal decision-making to mom having sole legal decision-making. It's very hard to overturn those decisions by a judge unless you can show that the judge's decision was contrary to law, which means that they didn't appropriately consider all of the evidence, or they ignored the evidence, or they didn't do the analysis. And in this case, looking at this ruling, it just seems like that would be almost impossible. But will the Court of Appeals take this and expand Arizona's domestic violence law to say affirmatively, yes, this pattern of behavior can and does and is domestic violence, which creates the legal presumption against joint legal decision-making? I don't know. That would be huge. The other thing is I was so flabbergasted and honestly emotionally moved by this ruling that I didn't tell you the outcome. So I inferred that, of course, sole legal decision-making went from dad to mom, and that is what happened. Mom got sole legal decision-making, and dad got every weekend of parenting time, Friday to Sunday. One of the reasons that the former parenting plan that led us to this case was so problematic is it gave dad sole legal decision-making and primary parenting time, and the court told dad to work out parenting time with mom every 2 weeks, and then mom was to have parenting time as she arranged it. Then dad didn't allow her to arrange it for a period of 3 years. Our parenting plan statute really doesn't allow for that. Our parenting plan statute requires that there be an actual schedule. You're not really even allowed to have a parenting plan that says what that former parenting plan said. But here we are. If you've got more questions on this case, parental alienation, domestic violence, family law, send in your questions. I am happy to answer them.